I'm here with Jeff Weiner, a renowned criminal defense attorney from Miami and former president of the NACDL, and also someone who has litigated before the United States Supreme Court. I've chosen to interview Mr. Weiner because he is a well-known trial lawyer across the United States. And in addition to that, I have the good fortune of working with his son, Fernando, under Bill Wolf at his firm in Chicago. So it's good to have you with us, Mr.
Thank
Weiner.
you so much. I'm very happy to be here, and I love what you're doing. I just think it's a real good service that you're doing, and I wish you the best as you enter our profession as a member of the Illinois Bar.
Well, thank you so much. I appreciate it. I make the videos so that up and coming lawyers can kind of get a sense of what the practice is like and try to get the real fundamentals from the best before they start learning bad habits. It's really what it's about. So can you tell us a little bit about your professional background? So what happened right after you graduated law school?
Well, when I was in law school at Chicago, Kent, in Chicago, an amazing, wonderful, spectacular,
top-rated in trial advocacy.
School. That's exactly right.
Yes.
So I interned in the Cook County Public Defender's Office, and I learned trial advocacy from Warren Wolfson, who was a professor at Chicago, Kent, later dean at DePaul, and he was an amazing criminal defense lawyer when I first met him. He also became a judge, and he's also a poet, and he's a beautiful man, and I love him, and he's special, and he's great. So I love Kent and what Kent did for me and the opportunities and the education. I'm honored that one of my four sons is at Chicago, Kent. My eldest son, Diego, went to St. Thomas University Law School in Miami, and he practices with me. He's a wonderful criminal defense lawyer. And now Fernando is at Chicago, Kent. My number 3 son, Max, is the pitching coordinator for the Seattle Mariners. And my youngest son, Jake, is a Harvard Law School graduate. So they're
an
all
outstanding
good.
family.
And I have a daughter too with 2 grandkids. So
I didn't know that. What? Tell me about your daughter.
She's the eldest. She lives in California. She's got a wonderful husband and 2
She's
great
the oldest.
kids. Yeah.
So did she bully all the brothers growing up?
Well, that didn't work with my boys. They were more looking out for her.
Oh, I see. It was the other way around. I got you. Okay.
Yeah.
Well, that's excellent. That's
so
excellent.
What happened was after the public defender's office, which was fantastic, I took the Illinois bar right out of law school and passed, went right back to my home in Florida, took the Florida bar, passed it, and began working for an excellent criminal defense firm in Miami. There were 4 of us. We did strictly criminal defense. By the way, in Illinois, I also worked with Ralph Rubner at the Illinois Defender Project, where I represented a fellow sentenced to death. And that was fascinating. And the opportunities to be in clinical programs is an opportunity that no aspiring criminal defense lawyer or trial lawyer should miss. You meet with your clients, you understand this is not just law book stuff. This is for real. This is someone's life, someone's freedom. It's the real deal. And you also learn that dealing with clients is not always the easiest thing. And you've got to learn how to do that too, and to be sympathetic and understanding for what they are going through, no matter what they were charged and or convicted of.
So can you tell me a little bit about your transition from that firm, which you said was a 4-person firm, into private practice on your own? What was that like? And what growing pains were there? What can lawyers learn that are just starting out, hanging their own shingle, as it were? What can they learn from your journey?
I had a great time for 2 years in this firm with 4 of us doing strictly criminal, state and federal, primarily in Miami, but I had cases even then in different parts of the country. So I had a string of not guilty verdicts with a lot of publicity, and these were the days before the internet really started. So the local newspapers covered all the trials, and it was very easy for a lawyer to get a lot of publicity if you had good cases and you were winning. And I was very, very fortunate in that regard. And after about 2 years, I decided I'm going to start my own firm. Three of the fellows in the first firm wanted to join me, but I think they were like, gee, you know, we're just starting out. I said, hey, look, I'm going. If you want to join me at some point, let me know. So I started my own firm. And after just a few months, two of my buddies from the first firm joined me, and we practiced together for 17 years. We had an amazing practice. At one point, we had 11 lawyers. We practiced just criminal defense. We had cases all over the country, and it was really a wonderful, wonderful experience. Also, young lawyers should be involved in criminal defense bar associations. I got involved in the National Association of Criminal Defense Lawyers, was on the board of directors for many years after being on various committees, and then worked my way up through the ranks, through contested elections, and ultimately in I think it was 90 and 91, I was president of the National Association of Criminal Defense Lawyers, which was the best honor that I can have in my profession, because all the excellent criminal defense lawyers, including the wonderful lawyer you work for, are active in NACDL. Many are on the board, many are officers, and to be elected president and to be a spokesperson for 10,000 criminal defense lawyers around the country was a spectacular honor. I spoke in over 25, 26 states representing NACDL. I testified before Congress, all sorts of things. I remember marching in Puerto Rico because the criminal defense lawyers were making about half the money that prosecutors were making. They had no money for investigators, law books, demonstrative evidence, computers, etc. So we had a march, and they went on strike to get them more money. I remember testifying in Louisiana as an expert witness, stating that the entire indigent defense system in Louisiana was unconstitutional because it was so unfair. And those are just two examples of many, many, many examples of being active for the good of the criminal defense bar and our clients and the Bill of Rights, all through the National Association of Criminal Defense Lawyers. I'm also a fellow of the American Board of Criminal Lawyers, and I'm involved in other organizations. I'm board certified, et cetera, but NACDL is spectacular.
I wanted to ask you, what was that organization you just mentioned?
The American Board of Criminal Lawyers.
Okay. So I recently, I like to know who the best lawyers are in the country. And I looked at this, great lawyer from Chicago, and he was a member of that organization. He had been a past president. And I messaged Bill about it. I said, we should look into joining this. And we noticed that it was invitation only. Can you tell me more about the organization? That would be a good, because it doesn't come up as often as the NACDL or NITA or NCDC or any of these various programs that are all trying to help the criminal bar. Can you tell a little bit about that?
I'll be happy to. And you mentioned NCDC. I was on the faculty in the Board of Regents for many years. That is a wonderful opportunity to be trained. The American Board of Criminal Lawyers is for experienced criminal defense lawyers. I believe you have to have either, I can't recall, 25 or 50 jury trials.
I think it's 50.
And so these days, and I've made this argument when I go to the meetings, and we're about to change some of the rules, because now with the sentencing guidelines, especially, it's very, very difficult for lawyers to get 50 jury trials. It's really, really difficult. And there are many great lawyers that should be eligible to be invited and to join. So to be a fellow in the ABCL, or American Board of Criminal Lawyers, it's a wonderful honor. It's a great group. We meet all over the world 4 times a year, stay at nice hotels, have a nice time. We have a round table where we usually have a speaker, and then the next day, all the fellows bring up cases that they have, many of which were sent around prior to the meeting. And the beauty of it is 30, 40, 50 lawyers who are present all opine on various legal issues, evidentiary issues, trial issues, ethical issues, etc. And it's a wonderful opportunity in that regard. So the American Board of Criminal Lawyers is special. It's very different than NACDL, very different. And they both have their place. But for a young lawyer starting out, which I know is your focus, NACDL is it, period, end of story.
Certainly,
And,
certainly.
and of course, your state and local criminal defense bar associations, which are all affiliated with NACDL. But
Like IACDL and
too many people say, I'll just join the local association. I don't need to pay the extra money for NACDL. That is a gigantic mistake for all reasons. NACDL offered so much. Should a young lawyer ever get in trouble, be held in contempt. The Champion magazine is spectacular.
Yes.
Comes out each month. We do serious lobbying. There's a million reasons to join NACDL.
Yes. What is as far as the other organization, what is the procedure for invitation? How do they know which lawyers to invite? Since a lawyer can't formally write in and say, hey, I've tried 50 jury trials, I've had high profile cases. How do they know? Because
we have members from every state, and the good lawyers, we all know each other. And so if a lawyer is really doing something right and winning cases, and look, it's not even winning cases. There are a lot of cases that are unwinnable. But if we're in there fighting the good fight, we're writing articles, we're speaking, we're writing letters to the editor, we're appearing on the media to stand up for good judges who maybe do something that's unpopular because they do the right thing, happens less frequently these days. Then the good lawyers know who these people are and they get the invitations. And, you know, it's not a snobbish type group at all. I mean, we have people from all walks of life who are fellows, men, women. There's no discrimination at all. Sort of like being a Freemason. There's no discrimination. It's very special, and everyone is welcome.
That's excellent. So you described your allegiance to the NACDL, which is really, really profound. It seems like you have a profound loyalty to the organization. I remember when I first reached out to Bill, he told me about it. I immediately joined, didn't even know it was a thing. And I encouraged all my law school friends to join the NACDL if they were at all interested in criminal defense. Absolutely. And there was some pushback from some of the public defenders who felt that the NACDL represented primarily private interests and private lawyer interests, which it doesn't make much sense because so many of them are previous public defenders. I mean, you have Bill Wolf, and from the Homicide Task Force in Chicago, you've got the federal defender, Barry Pollock. I mean, you have Larry Posner out of Colorado. I mean, they're all former public defenders. So, of
course, I would say probably, I don't have statistics, but it wouldn't surprise me if 30% of us are former public defenders. Really, that's wrong. And the public defenders, we have many who are members, some who have become presidents of the organization. So I hate hearing that sometimes there's like a split between public defenders and private criminal defense lawyers. No, there is not. We as private defense lawyers support public defenders. We love public defenders. We're there for public defenders. We're all fighting the same good fight to protect the Constitution and the Bill of Rights. So there is no split between us.
Good. That's good to hear. I want to move on now. You know, I have a set of issues I wanted to get to, but you added one to my list. You sent me an email and you said that you knew Richard Racehorse Haynes. And when you tell me something like that, that shuts everything else down. So tell me.
Racehorse was a wonderful lawyer, a major personality. The people in Texas primarily knew of him, loved his exploits, loved the trials that he was in and often won. He was a real personality. He was great. At the same time, there are many, many, many excellent criminal defense lawyers, easily of that caliber in their own way. And for example, Albert Krieger in Miami. my teacher,
Yes.
my mentor. He passed away about 2 years ago. A beautiful, beautiful man. And there's so many more excellent lawyers. But Racehorse was a character, a great guy, and it was a treat to know him, no question about it. He was a fighter to the end, as all good criminal defense lawyers are, and that's the story.
That's the story. Did you know, have any relationship with like Percy Foreman or Dan Cogdell or Dick DeGuerin?
Well, Dick DeGuerin, of course, yes. The other gentlemen, no. They were either before my time or I just never hooked up with them. This is my 48th year as a criminal defense lawyer. And I tell my son, who's in your firm, when I went to law school at Chicago Kent, back in 1970 is when I started, there were no computers. We had law books, and we just did not have computers. I'll never forget when these little calculators that now companies give out for free, when it came out, I was so blown away by it, and I'm not the greatest in math. I paid $50, which was a lot of money for a kid in law school who had no money, to get one, because I was so blown away by these little handheld calculators. But I often have a contest with the lawyers in my firm. When a legal issue comes up, I tell them, I'll hit the books, you hit Westlaw or Google or whatever you want, and let's see who gets the best case first. Of course, in this day and age, there aren't a lot of good cases, because it's sad to say, but the courts have become so conservative and so unfair in so many ways, led by the United States Supreme Court and by this ridiculous theory of original intent, and that the Constitution is not a living document. It's
Precisely.
absurd.
It
but
is.
so many people have bought into it that it's frightening. It's a shame. It's horrible. It's terrible. And starting with the Supreme Court for their disdain in most cases, not all, for the Bill of Rights, for women's rights, for minority rights, for criminal defendants' rights. We're in very rough times, and with the current makeup of the Supreme Court, for many decades to come, it's going to be a sad state of affairs. The days of the Earl Warren Court, when constitutional rights became very special, when motions to suppress were granted, when separation of church and state meant something, those days are over. And it's very, very sad.
I've heard Jerry Spence say that the Fourth Amendment, and you can take the whole Constitution here really, but the Fourth Amendment is kind of like the Bible. When the Supreme Court tries to look at it, they don't just take what it says, they try to find exceptions to it. And I thought that was funny and pretty an accurate description of the state of affairs regarding the Fourth Amendment. I understand that you argued a Fourth Amendment case in the United States Supreme Court. Would you talk a little bit about that, what that experience was like, and what it was like to moot it at Georgetown Law, which you must have done?
Yes, absolutely. And Bill Greenhall,
yes,
who has since passed, was a friend of mine. He was beautiful. And I'll tell you the lead into it, because I haven't thought about this in a while. And you mentioned Georgetown. What happened is, first, let me give you the facts. The case is Florida versus Jimeno. And what happened is the police were interested in a vehicle and the occupants of a vehicle, suspecting them of drug trafficking. They did not have probable cause. They're following the vehicle, and so they do what police routinely do. They make up a phony traffic violation to justify the stop. Once they stop this vehicle, to make a long story short and concise, they asked permission to search the vehicle. They said, can we search your car? The driver of the car made the mistake of saying, yes, you can search the car. So at that point, as you know, once consent is given, you don't need probable cause, you don't need a search warrant. But the consent that was given was consent to search the car. The police had no interest in searching the car. They went straight to a brown paper bag that was rolled up on the top, and inside of it, they found cocaine. A motion to suppress was filed in the trial court, and it was argued that the search went beyond the scope of the consent. The search was to search, the consent was to search the car, not closed containers in the car. And as Thurgood Marshall said, and what an honor it was to argue before him, Thurgood Marshall said during our oral argument that a brown paper bag to a poor person is the same as a fancy locked briefcase to somebody with more wealth and should be accorded the same respect.
That's
Anyway,
exactly right.
the Florida trial court in Miami agreed and suppressed the cocaine. The state appealed it to the intermediate appellate court called the Third District Court of Appeals, and they agreed with the trial court that the consent was given for the car, not for items, closed items in the car. This has nothing to do with plain view. If drugs were there or counterfeit bills or whatever, of course, if they're in plain view, they're in plain view if the initial stop was valid. But in any event, they agreed that this was an illegal search and seizure. They suppressed the cocaine. The state then appealed it to the Florida Supreme Court. And the Florida Supreme Court, then a court that respected constitutional rights, unlike the way it is now, they agreed with the trial court and the intermediate appellate court. But unfortunately, police organizations and the state filed a petition for certiorari before the United States Supreme Court. And as you would expect, as soon as cert was granted, knowing the makeup of the court, we knew we were in big trouble. So anyway, we moved the case at Georgetown. Bill Greenhall went to every Supreme Court argument. I loved him. He was a beautiful, special man, a credit to Georgetown law. And it reminds me of a story, not in my case, but another case. A Supreme Court case was being mooted, and one of the law students asked the question. The professor said, hey, come on, we need to get ready for the argument. This is the stupidest question I ever heard. And then former Chief Justice William Berger asked the same question during the actual argument.
Whoa.
But in any event, yeah.
Wow,
So,
it shows you what some professors know, huh?
you got it. You got it. So it also shows you the level of some of the questions, because people think that just because judges are judges or justices are justices, that they really understand what they're doing. And that's not always the case, especially if it involves a specialty area of law that they didn't practice when they were lawyers. A lot of them just don't have a clue. Anyway, so we mooted the case. I argued the case. Interestingly enough, I argued against John Roberts, now our Chief Justice, when he was, I think he had the title of Deputy Associate Solicitor General. He couldn't have been nicer. We had a good time arguing the case. I also argued against the Deputy Attorney General from Florida. And the bottom line is the argument went well. Turns out that Bill Greenhall said, hey, I don't know how it's possible, but I think maybe you salvaged this constitutional right. There was coincidentally a justice from the Florida Supreme Court that had voted to suppress, who was there watching. He came up after, great. And of course, as you would expect, we lost the argument. I had 2 votes, Thurgood Marshall and Justice John Paul Stevens of Chicago, 7th Circuit. And that's the story. And it's a real shame, because the attack on constitutional rights is ongoing, and it's being chipped away on a daily basis by all courts with conservative judges. And it's really a shame, because I'm all for the police being supported and doing their job. We need the police. I'm all for good, honest police, but not at the expense of individual rights. And that's what's happened now. It's a different world. Now, for a motion to suppress to be granted, it's a big deal. In my day, my early days in the 70s, 80s, 90s, they were granted routinely. Now the law is so bad that the police basically have free run to trample the Constitution. And one example, for example, are canine searches. This is the best, simplest example in the world. The police need merely to bring a police dog, most of whom are totally unqualified, untrained, and incompetent. And the handlers say, my dog alerted, and that gives them probable cause for a free search. It is a disgrace. It is a joke. The Supreme Court somehow believes that these are super dogs. And, any good police officer knows, hey, we don't need to worry about evidence, probable cause. Just bring the dog, say the dog alerted, and you get to search the car or, whatever. And it's just horrible that that's the way the law is. It's embarrassing.
And even if that canine unit is on camera, some kind of camera, and it's not apparent that they, even if they're on some kind of camera, and the officer knows that, well, I can't just say he alerted, I've got to make it look like that. They have ways, and this obviously, of getting dogs to alert.
Of course.
So that in the video, it looks just like the dog authentically alerted. Which is
I've had cases,
further problem with the kind of evidence.
I've had cases where cops stand in front of the video, put their back to it and pretending they didn't know, so you don't see. I had a federal case in Ohio where the dog urinated on the tire of a car, and the cop had the audacity to say that's an alert. And listen, the bottom line is anyone who has a dog as a pet or whoever did knows how easy it is to get your dog to do something, because the only incentive of a dog to alert is to get a treat, whether it's a toy, whether it's a snack, whether it's a rubber ball, whether it's a tug toy to play with. That's why they alert. They're not looking to be dog of the year. They don't care about narcotics. They just want their treat. So it doesn't take long for a dog to realize that, hey, if I just sit, I'm going to get a treat.
This is a pretty good gig. Yeah, for the dog.
Yeah, it's all bullshit. And what makes it even worse is when there is nothing that is found, no contraband, the police still routinely say, oh, my dog never misses. There must have been residual odor, for which there is zero evidence to support, much like Donald Trump's claim of phony election, for which there is zero evidence. It's the same thing. It's preposterous, but some judges actually believe it. It's unethical. It's disgraceful. And that's just one example of how the Bill of Rights has been trampled and has gone to the dogs.
So yes, gone to the dogs. That's very good. Did you use that you used that line before, I take it?
Well, I have, because one of the articles in the Champion that I wrote had that headline, and I liked it because it's exactly what has happened.
That's very clever. It's very fitting. Yeah. Very fitting. So let me ask you about trial advocacy. So cross-examination, something I am really, really passionate about. I love cross-examination. I read all the books. I've seen all the CLEs. As an undergrad, I did this. I was ready. I love cross-examination. What is your style?
Just coincidentally,
is
not expecting this.
Wellman. Yeah, Wellman. Yeah.
This is a great, great book. And there are many great ones out there, but I love that you love cross-examination. That's the key to everything.
Exactly.
Some people say it's jury selection, and that's super important. But, jurors watch TV, they watch movies, and when it comes to cross-examination, they expect cross-examination.
Everybody leans forward.
That's right.
So
and
with
a good lawyer, though, also knows that sometimes the best cross-examination is no questions, Your Honor, and move on.
Right.
What I don't like is lawyers who have a legal pad with all the questions written out, and they ask a question and they're looking at the legal pad for the next question. They're not listening to the answer, which could blow the whole case open, and they miss the whole damn thing because they're looking at their legal pad.
This is the number one piece of advice I've received from universally from great trial lawyers. Listen to, ask the question, listen to the answer. Don't focus on the list. Then ask a question based off their response. Otherwise, move on to your next question.
That's right.
It's
and
simple.
Many times you'll get an answer that is so powerful in your favor that you abandon your other questions and you've made the point, you sit down and you've now got it for closing. So you've got to always be able to act and react depending on what's happening in the courtroom.
So what is your personal style of cross-examination?
I'm not sure that there's a style. It depends on each case. Some cases you have to be aggressive. Other cases you have to lay back. and be very gentle, but make your points. Other cases, you want to be very, very detailed. In other cases, no, because you don't have the jury for that, and they're not really interested. There's so many factors. For example, very often the prosecution's case is long, drawn out, boring, and the last thing they want is from the defense to do the same. They want boom, 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 and there you go, and then you're ready for closing. So I don't believe that anyone should have a style. You've got to react just like you do to questions and answers. You've got to be able to react to the case. What you would do in a sophisticated federal money laundering case is very different than a self-defense murder case, for example. You want different jurors, you attack the case differently, and you've got to be flexible.
Who's the best cross-examiner that you've ever seen in action?
I would say Albert Krieger is great. There was a lawyer who also has passed away, the first lawyer I worked with in Miami, Paul Pollack, great cross-examiner. And I want to just say one more thing for you and for your listeners, and that's this. There are a lot of big name lawyers all over the country, and many deserve their great reputation. Some don't, most do. But I've handled cases all over the country, both state and federal, and some of the best lawyers that I've ever worked with are lawyers that are not known beyond their own little town. Great lawyers, spectacular lawyers, amazing lawyers, but they're not on TV. They don't write articles. They don't take cases, out of their local area. And so people don't know them. They're as good as the best, maybe better. And it's the same thing with law schools. I got a kid who went to Harvard. I know many Harvard grads. They're no better. They're no better than Kent grads or St. Thomas grads or Florida.
Definitely not at trial work. That is for sure.
Nothing. It doesn't matter. And, it's who you are as a lawyer. And look, any accredited law school is going to give you a good education. Although I must say some of these religious affiliated law schools concern me. I've met prosecutors from them. And to bring religion into cases, I believe is inappropriate. The same way as I believe that this freedom of religion, which I couldn't agree with more, somehow gives people who base their prejudice on religion the right to practice their religion at the expense of others. No, that's not what the law has been about, but unfortunately, that's what it is now. It's really embarrassing. And I used to love the appellate decisions that were so good. Now it's just sickening how so many courts, including the U.S. Supreme Court, does everything they can to get around protecting individual rights.
Certainly. And you mentioned in there that there are a lot of lawyers who are just as good as the best, but they're simply unrecognized, or they may not have the accolades, though they may well have the qualifications to earn them. I'm going to ask you, could I ask you a personal kind of professional question about me?
I'm not sure I'll answer it, but you can certainly ask.
Okay, sure. So I recently found a list that I made as an undergraduate of achievements I wanted in order in the law. And some of the first few were good: never defend a corporation or criminally prosecute an individual, learn from the best, go to the trial lawyers college, now the jury defense method.
Wait, if you don't mind, go back.
Yeah.
Never defend a corporation. Why?
I don't believe that the talents that I accrue, like all the hours at night working, should go to defend an entity that can probably hire somebody just as good as me. And something rubs me the wrong way. Usually, especially when they sue so-called little guys, whether that's a smaller corporation. Now, when I say corporation, it's also a matter of, could be, what I mean by that term. So if there's let's say there's a small family-owned ice cream company, or maybe they've got a few chains or something like that, but nothing big, and somehow someone else rips them off, and I'll represent that business. But a big corporation, I won't do it. I won't do it. As a promise, you will never, and nobody will ever see me represent a corporation.
Right. We'll see. Yeah. We'll see how life plays out. You know, there's a saying, when man plans, God laughs. So you never know. But anyway,
That's
go
true.
ahead with your list.
Okay. So, join a firm with a strong mentor, these are all basic good
Yes,
things, but then
very
I,
important.
then I began to notice a problem. And this is where this comes in with the accolades and especially my generation's obsession with recognition, and also with fame. I think that other generations have hit on that pretty well. And I'm not totally immune from that either, because I'm a human being and I'm of my generation. And so the next set of these accomplishments was really just rather self-centered, and it really kind of struck me. Like the Martindale Hubble, top 100 trial lawyers, US News and World Report, articles published in the Champion, articles published in American Journal of Trial Advocacy, CLEs presented at NEDA, NACDL, NCDC, Chambers and Partners, Band 1, 2 books, 1 mass market biography, 1 treatise on criminal law, leadership in an IACDL, officer position NACDL for set term, acquittal in international tribunal, admission to the American College of Trial Lawyers, star individual from Chambers and Partners, and then the ultimate goal is a Trial Lawyers Hall of Fame, and convince them to admit F. Lee Bailey, which he believed he deserved to be in there and he should be in there. And then go out to pasture as an old boxer, write a book on trial advocacy, hit the CLE circuit, and enjoy the conferences that I'll go to, despite the fact I won't be practicing. What struck me was that there seems to be a really adolescent, kind of immature desire for recognition in these list of professional goals. And what's missing is the underlying philosophical reason for doing what we do, to represent people who need help. And I was really disturbed by this. And I guess what I'd guess is that a lot of younger lawyers want to get into the prestigious firms. They want the accolades. They want all these things. What would you say? What other meaningful purpose or goal would you put before them to replace some of these more hollow, selfish whims?
Listen, writing articles, getting elected to a bar association that matters, like NACDL or local or state criminal defense bar associations, they're great. The accolades are secondary. It's the opportunity and the position to do the right thing, to keep the law on their toes, if you will. In other words, to protect constitutional rights. So a lot of the things you mentioned are perfectly fine and perfectly good. But in this day and age of social media, it used to be where if you got the top rating from Martindale Hubble, which I've had forever,
Used
it
to mean something, yeah. Now anybody can get it.
Every other day, it comes in the mail where there's not the great organizations like Best Lawyers in America, voted by your peers, Super Lawyers, voted by peers. But there's a whole bunch of ridiculous ones that, you send your money and, you're the top 50 lawyers in the country. I mean, it's ridiculous. And but in this era of social media, I think a lot of young lawyers, especially, who are trying to establish their reputation or get clients who click on their website to say, oh, I want to go to this lawyer, they need some credential that they don't have. So if they pay to get a ridiculous, I'm one of the top lawyers in the country type thing, when they clearly are not, and the organization is a joke, it's terrible. But the general public doesn't know that. They go, oh, wow, she was elected to this, he was elected to that. So social media has changed everything. It's no longer like with Racehorse Haynes or F. Lee Bailey, who I knew as well, and Albert Krieger and some of the really top lawyers who got the best cases because of reputation. Now it's social media, and a lot of people end up retaining lawyers that they later change from or are unhappy with because they believe the BS on the website. That's a problem.
How would you encourage criminal defense attorneys at a young age to cultivate a really good understanding for the human element in criminal law, and the not only the obligation to care about your client, but what that caring does for your effectiveness? How caring about your
the number one way is be a public defender, period. You get trial experience, you meet with clients who are down and out, who don't have money, oftentimes don't have family. Many have drug problems, many have mental problems, many have both. When you're done with that experience, and maybe you'll do it your whole career, but that experience will benefit you forever as a human being and as a criminal defense lawyer. You'll understand the family, you'll understand their kids, you'll understand the pressure, you'll understand how they grew up, you'll understand the problems, maybe why they committed the crime. Maybe there's not necessarily a defense, but explanations, mitigation, et cetera, et cetera. So if you really want to be a people person and be a better lawyer and understand their anguish, at least as much as you can, and their fright and their concern and their family's concern, being a public defender is doing God's work. And it's a beautiful, beautiful way to remain in or begin as a criminal defense lawyer.
And I would agree with that completely. And I would also urge like private attorneys to take on pro bono cases with public defenders' offices who can always use the help. My next question for you. So you have also had some success with international clients. You're one of the, honestly, you're one of the few attorneys who advertises that they practice international criminal law from the United States. Most are from other countries. And obviously there's a good reason for that, different systems. But how do you break into it? How does a firm, let's say 4 people break into international criminal law?
Well, here's the deal. International criminal law covers a wide variety of alleged crimes and a wide variety of circumstances. So, for example, an American citizen is traveling abroad and he or she gets arrested. The family members in the States don't know anybody in the foreign country. Knowing, for example, that we handle hundreds of international criminal law cases in my 48 years, they will call and say, Mr. Weiner, my son was arrested in Singapore or here or there. We've handled cases in South Africa, in Israel, in Peru. I mean, we've been all over. The bottom line is we then, through our connections, reach out to a fellow criminal defense lawyer that we either know or can vouch for. And what we'll do is we will fly over there. We will meet with the client. We will meet with the lawyer. If we like the lawyer, we feel the lawyer is reputable, competent, and good, we tell the family, I'm comfortable with this lawyer. Let's stick with her. Let's stick with him. Let's keep going. Or no, we've got to change lawyers. And we've had both situations. Another situation, we handle international extradition. So, for example, we get calls, somebody's arrested in the United States and they're wanted by a foreign country. We handle the international extradition, which is, of course, in federal court, and we handle it both through the trial level, which is often before a United States magistrate, right up through the appeal level. So that's another circumstance. In addition, there are many, many crimes that the United States has jurisdiction over that involve foreign countries. So international criminal law is crucial, whether it's unlicensed money transmission, money laundering, the obvious drugs, on a boat. Not so much anymore, but years ago, that was a big issue. A boat was intercepted in international waters and the United States asserted jurisdiction. But there are all sorts of crimes, white collar crimes, business crimes, tax crimes, money-related crimes that have an international component. And it's a fascinating area because you meet really great people, you learn about the different systems, and we give peace and comfort to the client and the American family that's scared to death, that doesn't know what the heck's going on in the foreign country. We bridge that gap for them. That's
really excellent. Good for you. I mean, in fact, there was a student at Georgetown Law named Austin Tice, and he was serving in the military and he was trapped in Syria. And yeah, as far as I know, he's still there. And so the university paid for all these different lawyers, and even paid for petitions to go around to Congress people. And I wrote a petition to my own, and it really is a situation which has real impact on people's lives. I mean, whether you're going to serve abroad in the military or whether you're just going there for a vacation, you didn't plan to be arrested. You don't know what their legal system is, and you are in a really vulnerable state. So it is excellent work that you're doing. How do you get involved in that? Like, how did you start? You just said one day, I want to be involved in this, and then you got a book on the international criminal law. I started reading it, or what did you do?
Here's another link to Chicago. When I got called in on the case, this was a case involving an alleged murder attempt on the Cuban consul in Merida, Mexico. And it was a very interesting case in which the Cuban consul's bodyguard was killed. It was fascinating. So I turned to my dear friend, Sharif Bassioni, who was then a professor at DePaul University, and in my opinion, the absolute leader in international criminal law. And I flew up there, I met with him, I spoke with him, we became dear friends. We've handled cases in Switzerland. We've handled many, many cases together through the years. And, his expertise and insight was of great help to me. His books were of great help to me. And as you mentioned, having a mentor to learn ethics and what not to do and how not to get jammed up in a problem. Well, it's the same thing in any area of law. Sharif was not so much a trial lawyer, but a genius, an expert, and was great and answered all my questions, worked with me, and gave me the info I needed to go forward and to effectively represent my clients.
So a lot of research and a mentor with a lot of familiarity in the area would be the primary ways.
To your question directly, how you get started, a lot of times lawyers get started by a fluke. Somebody comes in and you go, this is an interesting case. Let me see. And before you know it, it's fascinating. You love it. You handle it. You do well. And word spreads. And there you go. I know many lawyers who are handling unique areas of law that they never even thought about, never even took a course in law school on, but they loved it. And before you know it, they got a corporate client that you won't represent. And the corporate client does this, and they get into that area. And, keep the door open. That's my message. And
I'll represent CEOs.
I got it. Well, let me tell you, the best thing about law, criminal defense law, is when we take cases, and it's not just criminal defense, any lawyer, if you do more than just one little unique area of law, you learn about everything. I mean, I had a case years ago where this fellow was accused of manufacturing substandard screws to bolt pilot chairs into our fighter jets. I learned all about metallurgy, met with the experts. I've had knife cases, for example, same thing, metallurgy on the components, self-defense. I've taken so many courses with Masad Ayub, John Farnham, other experts on handguns, and not the law of handguns, but handguns and how they work, and the difference between this and that, and the different calibers and automatics and revolvers and semi-automatics. So when I get a gun case, I know what I'm talking about. That's all because of being a lawyer, where you learn. I've represented Olympic athletes, and I had to learn about their sport. I've represented jockeys, and being a horseman, which I am, I knew about lead changes and bumping horses and amazing things. So being a lawyer is great. If you take a variety of cases, you never stop learning and being interested.
Well,
that makes all the difference in the world.
First of all, definitely, I have an appreciation for the fact that you continue to go to these CLEs. A lot of lawyers and even doctors, like, they won't go to any conferences once they graduate, and they'll just keep practicing and make their living. And that's not the kind of lawyer that I think my listeners want to be, and that's not the kind of lawyer I want to be. So that's the first thing I'd say. Second, glad that you're a horse rider. That's really cool, because I, being from Wyoming, have been on I've been on many horses, and I think it's fantastic opportunity to bond with an animal. More, usually people with dogs, but I think it's just it's soothing. It's soothing, especially
It's
after
great.
being in DC with all the sirens and everything. It's good to sit on a saddle.
Absolutely. I competed with jumpers for many years, saddlebreds, standard breds, cutting horses. It's great. It's a great sport.
Yeah.
And, when you talk about young lawyers building up their practice, I ride motorcycles, I ride horses, I go to the gun range, I'm a Freemason. The more you spread yourself out, the more people you meet, the more cases you get, and the more you're a human being. These lawyers that somehow take pride in working, 7 days a week, they never get out, they don't get married. If they're married, they get divorced. Oh, I love the law. That's my whole life. No, they're not the good lawyers. The good lawyers are out and about. The good lawyers know about the current TV shows. The good lawyers know about current movies to make references. The good lawyers have interests beyond the law.
I heard it said by Tom Mesereau that in order to become a good trial lawyer, the first thing you have to do is begin to understand the mentality of the common person. And he did it by going to bars in the jurisdiction where the Michael Jackson case was tried and just talking to people. And that's how he selected his jury. It's not
That's
very
who jurors
scientifically.
are.
That's
Yeah,
jurors are
jurors
people.
want nice
They-
people to be
yeah.
lawyers, because our credibility is on the line. As much as the case is not about us, it's about the facts and the defendant or the plaintiff, or if you're a plaintiff's lawyer. If the lawyer is likable and has credibility and is doing his or her job, that means so much for the client. Recently, the case in the news with Amber Heard, et
Yes.
cetera. There was a lot of talk about one group of lawyers being super nice, sharp, on the ball, and the other lawyers maybe not being so. I'm not taking an opinion or a side on that, giving an opinion, but the point is well made. If the jurors like the lawyer, it matters. It matters.
Related to the Amber Heard thing and what you just said about not wanting to give an opinion, what is your opinion about lawyers who become consultants legal consultants for the media, and then proceed to commentate about the case without ever walking into the courtroom?
Well, that's a great question. I got to tell you, I am so impressed with you. Your demeanor, your questions are fantastic.
Well, thank you. That means a lot.
For many years, I did legal commentary on various national and local networks as their so-called legal expert. But I always made it clear that I am not privy to a lot of the facts. I just know what the public knows. And so I can comment without always taking the defense side, without taking the prosecutor's side as a rule. I would tell it like I saw it, but always give the benefit of the doubt to the trial lawyers who understand, who have tactics, who have planned, who are in the arena, as Teddy Roosevelt said. And a legal commentator is not. So legal commentators have a duty and an obligation, in my view, to be fair, to be reasonable, and not to make final judgment calls except in the most unusual situations where that call is appropriate and fair. I remember doing commentary on the O.J. Simpson trial every day of that trial. And it was ridiculous for some of the commentators who treated it like a tennis match, like, okay, now for sure the prosecution's got him. And no, now the defense wins for sure. In the first few days of the trial. I mean, it's ridiculous. So if we are experts, our job is to educate the public, keep an open mind, and to be fair to both sides. I remember when General Noriega was on trial. I don't know if you recall that, but you know,
I know
the
of it. Yeah.
United States went in, we basically started a war and captured Noriega and brought him here on drug charges, and he was tried. And I remember making comments against the prosecution, the federal government, on the air, and the U.S. attorney met with me, took me to lunch, and Jeff, you know, please, you know, you got to stop. I said, no, I'm not going to stop. I'm going to tell it like it is, good, bad, or otherwise. And that's the way it is. And that's what I did. So you
He
cannot
asked
be
you to
intimidated.
stop.
Yeah. He said, come on, you're really prejudicing people against us. I said, listen, when you do things that, in my opinion, you meaning the agents, the prosecutors, that are inappropriate, I am going to say so. And that's the way it is.
Yeah.
And
How dare he?
you're right. But
How dare he?
we've been friendly always. And but I stand my ground, and any good lawyer is going to do it. Unlike, for example, the Republicans in the House and in the Senate that, you know this thing with Trump, and then now we're like, oh no, it was just a little tourist event. No, you know, you've got to have courage, you got to have integrity, and you've got to speak the truth.
That's certainly true. What are the? I've heard about. I don't know another word for this other than courageous or like ballsy. What are the most courageous presidents of the NACDL that you can think of where they undertook some effort that really took a lot of guts? I've heard from Bill that John Wesley Hall once printed out a stack of articles from the Champion and took them in somewhere and was just on fire. What are some stories you can tell us about that?
Well, I've got to say that virtually every NACDL president has been a superstar in his or her own way. For example, Barry Scheck, a dear friend, you know, with the O.J. Simpson trial, he became world famous. With his knowledge of DNA, world famous. With his starting the Innocence Project, he has saved, I believe, well over 70 lives of innocent people who were on death row to be executed. Other lawyers don't have that focus and that kind of publicity, but in their own way are pushing legal education,
exactly.
are sponsoring amicus briefs. I mean, virtually every NACDL president, in my view, has been a star. And that's why I tell you, it is really the high point of my career, because I love being a criminal defense lawyer. I love the members of NACDL. I love what we stand for. I love what we fight for. I love how we care about the Bill of Rights. And so I don't want to single out individuals, but that example with Barry Scheck is just one of maybe 30 or 40 through the years that have been NACDL presidents, maybe more now. I think we're 50 years old, something like that.
Let me pivot from the NACDL. Let me ask you about law students or specifically law graduates. What's the biggest misapprehension, the biggest false premise that the average law student, 3L or graduate, has about criminal law and maybe trial law generally?
I think that the overwhelming majority of law graduates, and you know this better than I, but I lecture at law schools all over, and very few want to do criminal law. A lot of them owe a lot of money. You know, some of these law schools,
including me,
60, 65, 70,000 a year. And that doesn't include books and room and board. So they come out owing, you know, $250,000 or more. So they're like, hey, I can't take a job with the public defender that's paying me 65 grand a year. I've got to earn more. I've got to try to get into a big firm, or I've got to do boring civil work where I'll never see a courtroom for years. And I got to put in ridiculous hours because I got to pay off my student loans. I get it. I understand it. But you got to do what your passion is. And if you became a lawyer to help people, then become a public defender, then become a legal aid lawyer, become a prosecutor and be a fair one. But do what your heart tells you. I see lawyers all the time that are wanting jobs at our law firm and others that are in a big firm. They hate it. They hate the hours. They hate the garbage work they do. They hate the phony hourly billing where they reinvent the wheel in every case, where they never get to go to court. And they're like, this is a big mistake. I don't even want to practice law anymore. I see it all the time. So the answer to your question from my point of view is do what your passion is. The money will take care of itself. It will. It will.
Yeah. And I think, like you said, my generation has a lot of anxiety about student loans generally, and not just in the law, but, you know, especially doctors. Do you work for a nonprofit? Do you go with Doctors Without Borders? When you have medical school loans, which are even more expensive than law school loans, this problem is something that we really need to deal with in terms of social policy. Absolutely.
You're right. You're right. And that's not to diminish the fact that when you owe a lot of money and interest is running, that's a real factor. Absolutely.
Oh, of course.
Real.
I mean, it's exigent. You've got to address it.
Yeah.
Yeah. You've got to do what you have to do. But
That's
like
right.
you point out, it is a shame that people are forced to do that rather than doing what they're passionate about. We would see a lot happier people, and I think the legal system would work better.
That's why state law schools are so good, or
Yes.
law schools that give scholarships to worthy people so that you don't come out owing $250,000, you know?
Yes.
There's no reason for that. There's just no, I mean, law education shouldn't cost 65 grand a year. That's ridiculous. There's no
Maybe
reason.
it shouldn't even be 3 years. There's talk of that.
I know there's talk of making it 2. I don't like that. I think the 3 is important. I also think an internship should be required.
Oh, yeah.
Like for
agreed.
CPAs, they've got to work for a CPA for a year.
Yep.
Lawyers should come out and have to work for a legal aid organization, a private lawyer, somebody to really learn. Because when you get out of law school, I don't care if you got straight A's and you aced the LSAT, you don't know anything.
You don't know
Period.
anything.
To me, it takes 4 or 5 years minimum to become a real criminal defense lawyer. At least 3, 4 years, 5 years minimum, and maybe more. So internship, I believe, is very, very, very important and should be required.
Oh, I totally agree with you. I think so. And for school credit, and maybe that's where the 3rd year comes in.
Understood. Makes sense. Makes sense.
Let me see here. I have some more questions. I think we've gotten to a great deal. So some lawyers believe that there's something called a career case, that if you, let's say, for example, that I was approached, I was actually barred, which, you know, hopefully I passed a bar, that would be great. But let's say I was approached by Michael Jackson, for instance. He said, okay, I want you to take this case. And I have knowledge of everything in the media about that case. My first thought, this is my first major high profile client, is if I take this case and lose it, then I will be known as the lawyer who lost the Michael Jackson case. And so, but if I don't take it, then that could have been a career case I could have won and used to take in all these other cases. That's how these particular lawyers see the idea of a career case. Do you agree with that idea, concept of a career case?
I think that is absolutely so. Not for everyone, but yes, it's so. I would urge you in your example to have taken the case, because if you do a good job, that's what matters. Now, look at the Amber Heard case that just finished that we referred to. The incredible lady lawyer, I don't recall her name, against
who crossed Amber Heard?
Say again?
Who crossed Amber Heard?
She is now a superstar and well-deserved. I can't recall her name, but she conducted herself beautifully in every regard. She's now a superstar. So there's an example of a career case. She's set for life now, and properly so. She did a spectacular job, and I'm sorry I don't recall her name, but I was so impressed with her and her interviews after the fact, and how she spoke and how she looked in court and how she handled herself and how she was persistent yet still respectful. She was just great. And so, yes, there are cases. Look, you mentioned Racehorse Haynes when he had the Cullen Davis trial. A lot of times we take cases that are absolute, we think possibly losers, but everyone's entitled to a defense, and hey, you never know. So I'm all for it. You know, you cannot be one of these lawyers that only takes cases that he or she thinks they can win.
Exactly.
That's ridiculous. That's like I hear when people are shopping lawyers. Oh, I spoke to this lawyer. He said he never lost the case. I said, well, he probably didn't try more than 1 or 2 cases, if
Yeah.
that's the case, because we all lose cases if
We
you
all
go to
lose
trial
cases.
and if you fight them. That's the way
Yeah.
it works, you know.
Yes. Yeah. And I think that we need, well, it's a good thing that the legal ethics in, I think, every state forbid people like putting their records on their websites. I think that would be disastrous for
Yeah, they're
the
meaningless.
legal consumers.
Look, what's
Yeah,
a
they're
win?
meaningless.
Sure, like in criminal law, what's a win? Your client's facing 60 years in federal court, and through your good legal work, you get a plea. If that's, in other words, if it's not a case that is going to go to trial, your client
Right.
doesn't want to go to trial, and you get a plea to 18 months. Is that a win? Of course, it's a gigantic win. But what does a win mean? You know, in that circumstance, it's a win. I know cases where people are charged with crimes and they're looking at minimum mandatory 10 years, whatever. And they got kids at home. They got a wife who's ill, or a husband who's ill, whatever. And they said, listen, if you can get me a plea to, 6 months, I'll take it. I've got no choice, even though I'm innocent. And so we do it. Is that a win? Yeah, it's sickening. It's a win. But as we all know, defendants pay what we say rent for the courtroom. You go to trial and lose, you're going to pay for it. It shouldn't be that way, but with most judges, it is.
Trial
with the
tax.
ridiculous and horrible sentencing guidelines, that's always almost the case. If you go to trial and lose, you pay the price. So for example, if you were offered a plea, just take an example of 5 years in a very serious federal case, 60 months, and you turn it down and go to trial, you get convicted, you could easily get 10, 15 years. You're the same person that the government offered 5 years to, but because you exercise your right to go to trial, you pay the price.
Yeah.
That's not right.
And I've seen a ton of great literature from the legal community and from the academic community on the trial tax, which has said the same thing.
Right.
Why are we
Yeah.
punishing people for exercising their rights?
The judges usually don't want to go to trial. Many are lazy.
Yep.
They really push pleas. And when there's no plea, it's like, okay.
Exactly. They want to keep the train moving. I have one final question for you, Mr. Weiner. If I noticed that
Call me Jeff. That's my name.
Okay, for my last question, I'll call you Jeff. So Jeff, I got one last question for you. If, let's say, in any discipline, it seems to me, there's a small gap between the super really good and the great. And it involves honing a very sharpening skills to a finer point than the people who are just merely good. And it requires learning a lot of the subtleties with persuasion and being developing a style and a confidence. I guess what would you say are some things that are done by the great lawyers that distinguish them from the good lawyers? Some really hyper specific things that people usually don't think about, some really advanced stuff. What do you think?
It's a very interesting question. I have been asked for many years to give a speech called Being a Lawyer to Be Reckoned With. And I list maybe 100 different things that I believe the best lawyers do and do all the time. Starting with preparation. There's staying up to 3, 4 in the morning to prepare, to knowing exactly where you're going in a case matters. But more importantly, I believe there are a myriad of things that matter, from how friendly you are to court personnel, how courteous you are to people, how you dress, how you stand, how you speak, how you treat witnesses, both on your side and opposing witnesses, how respectful you are to the court without yielding your legal position, how involved you are in the community, there are so many different things that goes into making a lawyer to be reckoned with, a real lawyer that the prosecutors, the judges, the agents all respect, and that jurors like and enjoy watching. I think that's so important. I mean, it starts with when you're in a small community, you know, you cut someone off to get that parking space, and it turns out it's the judge's secretary who goes in and says, hey, you know, judge, that lawyer in court, what a jerk. Or
Yep.
I've seen lawyers call up the judge's secretaries, they call them judicial assistants these days, and they're nasty to them. Stupid, nasty to court clerks, nasty to the bailiffs. Think that, oh, gee, I'm a lawyer, I'm above other people. No, no, nobody's above anyone. That's why I love Freemasonry. We're all equal.
If
We're all
anything,
equal.
your obligation's higher as a lawyer, I think, for
Yes,
those
it's
values.
interesting that
Should
you
be.
use that word obligation. That's right. We're
Yeah.
professionals and we've got to act like it all the time, not just when we're in court, all the time.
But Jeff, something tells me that you're going to need to send me that article, that with the 150 ways. I'll put it in the description of the
It's
video
a
if
speech.
it's
It's
available.
not yet an article, but
Oh
it's
no! Do
in
you have
it's
the?
almost final draft of being a book, and I will send it to you because you're an amazing young man, and I'm really happy for your future and for what you're doing for the profession. And you're going to be a star. I know that.
It really means a lot that you said that, Jeff. Thank you very much. That's high praise
Sure.
from someone like you. I really appreciate it.
It's
And I'd
my
like to thank you for taking the time to talk with me today and to educate the young lawyers who are watching my channel and to hopefully inspire a generation of lawyers who can be reckoned with.
Well, I love it. Yeah, I love what you just said. Look at it. You get all dressed up for the interview, you prepare. I mean, that's great. You know, here you are studying for the Illinois bar, and yet you're taking the time to do this. And I'm honored that you asked me, and I hope this was worthwhile.
Oh, it was. Thank you so much for your time, Jeff.
Thank you. Good day.